My concern here is public safety. I don't care about your baby. I don't care about your grandmother. I don't care about your husband. I don't give a rat's ass about anything about that. But with you, DWI, FSGI, retaliation, DWI, assault of a public servant. That's why I have my eye on you. Only time will tell. You can shed as many tears as you want, but the real test is, what are you going to be doing when you're faced with the dilemma, when you're out there at a bar? Are you going to get in a car again, even if it's 15 years away?
Welcome back to the channel. Today's case is one of those emotionally charged, high-stakes courtroom showdowns that reminds us why judges sometimes have the most difficult job in the justice system. What you're about to watch is a powerful mix of public safety concerns, mental health struggles, addiction battles, and a judge who has clearly reached a breaking point after giving someone multiple second chances. Our defendant today has a history that includes DWI offenses, retaliation, assault on a public servant, and a long record of risky behavior that puts the community on edge. The judge wastes no time making it clear, this isn't about sympathy, or excuses, or tragic backstories. This is about preventing another tragedy before it happens. But what makes this hearing so intense isn't just the judges' frustration, it's the emotional avalanche that unfolds from the defendant. We hear trauma.
It's not her stepmother, is a stepmother of her son. There was a custody battle going on. It is a very highly contested one. So it doesn't surprise me that she is reaching out saying this. And then unless there is something else that you have substantiating this, Your Honor, this is just throwing mud. As far as I'm concerned, they're trying to take her son out of state, which is a pretty big deal. And
My only concern is that if, in fact, she is driving, come up, Miss Velma.
And I asked her, who's transporting her son? It's her grandmother, who is more than willing to vouch. Her grandmother transports him, and so does her mother. But she has not been driving.
I want you to read that letter.
And it is the same individual.
This opening sets the tone of the entire hearing. Notice how the judge immediately strips away every emotional shield the defendant tries to hide behind the baby, the family, the circumstances. He doesn't want excuses, and he doesn't want sympathy points. He wants accountability. Judges in DWI-heavy courts see firsthand how quickly impaired driving turns into death, trauma, and lifelong consequences. So when he says he doesn't care about the baby or the grandmother, what he really means is this: none of that matters if you end up killing someone. For viewers, do you think the judge's bluntness is effective, or is it too harsh? Let me know what side you're on.
I don't care. My only concern is if she's driving. So help me.
Yeah, they're doing a lot. They've also called CPS, which I haven't even had my son, and they're calling CPS and telling them a lot of this is
just probably with your criminal history.
I understand.
Right. I mean,
I understand.
Put yourselves in the shoes of someone else, right? Would you want a baby in the custody of someone that has that kind of criminal history? You know? Really?
His father has criminal history as well, and
I don't.
This is one of the emotional peaks of the hearing. The defendant opens up about losing custody of a daughter, her brother's tragic suicide, and the heavy PTSD she still carries. It's heartbreaking, and yet, in the courtroom, emotional pain doesn't erase legal obligations. The judge acknowledges her trauma but refuses to let it shift the focus away from child safety and public responsibility. It's a harsh truth. The legal system doesn't operate on feelings. It operates on action. Question for the audience: is the judge being fair in separating her trauma from her responsibilities, or should he show more empathy?
You're trying to justify it.
If you just can give me 2 seconds. I've never used that against him. I lost my daughter from a different father, so he doesn't know anything that I've been going through. My brother killed himself in 2016 in the parking lot of the Harris County Sheriff's Department on Clay Road. I don't know if you heard about it or saw the news article.
I understand that you have issues. I get it.
But what I'm saying is I've never used any of that against them. I've been very amicable with them.
We're having two different conversations. We're having two different, like, what I'm trying to impart to you is that you're talking about custody, right? And I am too, but I'm talking you having custody of someone. What matters is, and you know, when you're single, it's all about you, right? You can do whatever the hell you want to do. You can go with you.
This section is a powerful reminder of what judges consider when dealing with parents who have criminal histories. The judge breaks it down simply. When you have a child, your life stops being about you. Your decisions, your habits, your partners, your addictions, everything affects the child. And for someone with her record, the baggage, as the judge calls it, it becomes a real risk factor. This is a lesson many struggling parents face in family court. The court doesn't care if you're a good person deep down. They care if you can provide a safe environment. Do you think her past truly makes her unfit, or can people with trauma still be great parents?
You can go here, you can go there, you can stay up 3 days, doing whatever you want to do. When you get married, it's about your significant other, right? You always think about your significant other because that's what a marriage is, right? It's a chain link fence. And when the link is broken too much, the fence falls apart. When you have a kid, it's not about you. It's not about your significant other. It's only about the baby. Nothing else matters. And that's why two people who cannot get along, who have drug issues, have no business bringing another life because they can't even take care of themselves. And you, with the baggage that you have, while you may be a great person, there's too much drama, too much PTSD for a baby to put into them.
This moment shows the judge reaching maximum frustration. When he says so, help me, I'm going to freaking lose it. That's not theater, that is genuine judicial exhaustion. Multiple DWIs, repeated warnings, and now reports she might be driving again. To a judge, that signals danger, recklessness, and defiance. Driving under a court order is one of the fastest ways to get locked up. If the judge suspects she's lying or ignoring the rules, he can and will revoke her bond instantly. If you were the judge here, would you trust her based on what you've heard so far?
Because everything that you do will impact the baby one way or the other. I don't care what they've done. I don't care what they're doing. I don't care how many cases. You are the one that has the baby. You need to make the sound decision. I know you don't have the baby, but what I'm telling you, if and you do at some point, my concern here is public safety. I don't care about your baby. I don't care about your grandmother. I don't care about your husband. I don't give a rat's ass about anything about that. But with you, DWI, FSGI, retaliation, DWI, assault of a public servant. That's why I have my eye on you. And when I have someone telling me that you're driving now repeatedly, I have a big problem with that because I've ordered you not to drive and I had you sign an affidavit. And so help me, if I find that you're driving one way or the other, I'm going to freaking lose it. You better not be driving. I don't care what is going on in your life. I don't care who you have to pick up. Do you understand me? Tell me, has she done the AANA that she was supposed to do?
Yes, Your Honor. I think because there is no transportation, no driving, and the mother works 12 hours a day, the grandmother works, the grandfather works. I think you suggested her going online, which she did. I know that didn't turn out to be suitable. I told her to find something near her. She could go something in person where there is a sign-in sheet. She actually now has a sponsor. This is the place she's attending now. The sponsor's name's on the back. It's the first name, Rebecca. Rebecca is suggesting, since she's early in her treatments, that she suggests she go once a day, every day. She wanted her to go today at noon. She told her she was going to be in court. But she also is willing and in agreement to go every day. She likes this person. And so I think this is going to be her new place. She went to one other place as well this weekend on Fry Road, which isn't too far. There was no sign-in sheet. She got somebody to sign this little paper.
This is a schedule. This doesn't tell me that she's attended, though.
Right. I know.
Do we have any proof that she's done anything?
Classes she went to, she got her.
I don't care about that. I told you to bring a sheet of paper signed Did you do that?
I got one printed out. My mom works on Saturday and Sunday from 9 to 9, so
Do you have anything here today with proof that you've gone to any AA meetings or NA meetings?
you get these chips, and that's my sponsor.
Open your bond. She goes with you, please. I'm sorry, Joaquina. I've more than enough. I've literally. That's it.
Yeah, and I know one of the places they said because of anonymity, they couldn't give her.
This part is crucial. The judge asked for one simple thing: proof of AA meetings. Not excuses, not schedules, physical proof. When defendants fail to provide documentation, courts interpret it as known compliance, even if the person genuinely attended. Paperwork is everything. The defense tries to save the situation by explaining transportation issues, online meetings, and getting a sponsor, but the judge does not budge. He wants structure, routine, and accountability. This is where many viewers disagree. Should logistical difficulties be considered valid obstacles? Or should defendants find a way no matter what? Where do you stand?
That's not true. It's not true. I'll give this to you. I don't know.
Question on Vielma, with defense, we reached an agreement of probation. Would you take that today?
Yes, but I want her to go to sober court, and I'm gonna make that a condition though, but I'm okay with it. So, what we'll do is we will set her up for a TRAS today.
She's scheduled for May 1st on the TRAS.
Great. But I'm okay with it. But I 100%, she needs sober court.
Yeah, I agree. I
So-
think too. Okay.
We just wanted to make sure, because there wouldn't be a bond to revoke at that point. I don't know if you want to keep her in custody, but we reached an agreement today. So that's why I wanted to make sure.
And I'm gonna admonish her today, like, I'm gonna let her out.
Yeah.
But the exact conditions that I did now will apply. And so if she fails now, I'm gonna issue a warrant. And then this time I'm gonna keep her in custody until she does everything.
Okay.
So that's it. Are you ready? You ready?
Yeah.
Thank you. Hey, thank you for helping us out. I know that she's high maintenance. I wanted to be like this for her. I wanted to make it as a miserable experience so that she gets it. Unfortunately, you're in the crossfire, and I'm sorry, but I have a method to the madness.
Yeah.
Because, when people have really, really miserable experiences here, that's when they really start to think twice. God, I really had such a bad experience. I don't want to come back.
Right.
I don't know if that was this yet, because we're pleading now,
Yeah.
but we'll see.
Yeah. No.
But thank you, and I'm sorry that you had to go through this with us.
Oh, are you done with first?
Until she gets into sober court, she will report here to us. She was not going out to the region. She will report to me here, okay? And at the first instance, she stops doing, then we issue the warrant. She goes into custody and waits in there until the TRAS gets done. If you think that this is the easy way out, you are 100% mistaken. I told you that I was going to make it a miserable experience, and that's what I'm going to do. You will be expected to continue with what you were doing now. And at the first instance you try to toy with me, I will issue a warrant for your arrest. I'm going to put you in jail. And now you will be stuck like Chuck, because I'm going to put you in a rehab facility in the jail. It's a minimum of 9 months, depending on how well you respond to treatment. And if you don't respond well, you're looking at about 1.5 years in custody. I'm going to do everything in my power to make sure that you're not going to kill yourself. More importantly, anyone else. And if that means keeping you with me, I'm going to do it in a heartbeat. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. So what I want to do with you is sober court. Sober court is a program that helps you get your life on track. And if you do well with them, they help you get a license for you to drive. But it's a program that's
This case wraps up with the judge laying out one of the most intense sets of conditions we've seen. Daily drug testing 3 times a week, sober court, DWI, education, victim panels, anger management, a full treatment plan, and strict no driving orders. And he makes one thing clear: if she slips even once, she's going straight to jail and straight into long-term rehabilitation. The judge's message is simple. This isn't punishment, it's prevention. Prevention of another DWI, another tragedy, another family destroyed. Whether the defendant sees it that way is the real question. Only time will tell if these consequences lead to change or more chaos. If you found this case as shocking as we did, make sure to hit that like button, drop your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Your support helps us bring even more unbelievable cases straight to your screen.